My name is Jennifer Davidson. I'm a technology and IP lawyer from Toronto, Canada. I'm going to share my screen here so we can get my presentation up and running. So I'm hopeful that you can all see my screen now. So what exactly is IP? We've got patents, trademarks, copyrights, industrial design, trade secrets, and just a few others. And the Coke bottle is a really good example of all of these. You've got a patent in the bottling method of the Coca-Cola bottle, trademark of the Coca-Cola logo. You've got copyright and statements such as, what is it now? Taste the refreshing flavor. Trade secrets in the formula of the pop, and industrial design in the pop bottle shape. So I'm going to go over each of these and talk a little bit about what they are. Patents, they have to be new, useful, and non-obvious in order to be granted. They're for inventions, and it grants you a 20-year monopoly over the claimed invention. It gives the invention that monopoly within the country with which the patent is granted. Patents provide a time-limited, legally protected, exclusive right to make, use, and sell an invention. Trademarks protect the actual trade name that you're operating under. So Coca-Cola is allowed to use that name, but you're not allowed to create things that are similar, such as this Enjoy Chica Coloca situation here. We've got the Coca-Cola bottle itself is covered by no less than 20 different trademarks, and you can see a little listing of all the different US registered trademarks that they've got available there for them. And it's in order to make sure that your brand is yours and that the consumers can recognize you from others within the industry, in the marketplace. Copyright. So copyright applies to any fixed work. That can be a literary work, a musical work, performance work. Copyright exists in your apps, in your code, in your interface. And in most countries, copyright applies whether you register or not. Industrial designs protect the actual shape of the instrument that you're working with. So if you're working with a GUI, it's protecting the look of the GUI. It is a better choice than patents in certain circumstances because it's less expensive to do and provides pretty much the same guarantee, it only covers you for the actual shape and look and feel of the interface or of the design that you're working with. It will not protect you from other things. Trade secret. So trade secret is very interesting. It, as opposed to patents, which grants you the 20-year limited right and exclusive monopoly, a trade secret is indefinite. It will last as long as your secrets last. So for some circumstances, it's very useful to keep a trade secret as opposed to registering a patent. With patents, you do get the 20-year limited or unlimited right in the country that you've got it granted in, but that right will expire after 20 years, and after 20 years, anyone can make that invention. With trade secret, as long as you can keep it a secret, you can keep it as a proprietary piece of information. And a valuable piece of information at that. However, once it's out and you've lost it. Coca-Cola is a great example of a trade secret. They've kept their formula secret for over 100 years, and that trade secret is considered to be one of the most valuable trade secrets in the world. So some things to start thinking about when you've got your IP. One of the things that you'll really want to do from the very beginning is make sure that you own your IP right throughout. And that means making sure that with all employees, you've got agreements with them to make sure that you're clearly outlining who owns the IP. And because IP cannot be assigned proactively, you'll also want to make sure your employee agreements include a clause that allows you to ask them to assign the IP on a periodic basis throughout the project's development. Same thing goes for third-party contractors. You'll want to define within the agreement who owns the IP right at the outset, and also make sure that they will assign the IP over to you throughout the project as new IP is created, in order to make sure that you've got the ownership of the IP on the outset of the project. The IP itself is going to be valuable to you as you go through, particularly with investors, and making sure that you've got the opportunity to show investors that you own the IP outright. Oftentimes, investors will demand to see these assignments before investing within your company. Another thing to make sure of is that you've got moral rights waivers. Now, at least in Canada, moral rights cannot be assigned. They can only be waived. So it's important to separately and include within all of these agreements a moral rights waiver for every individual that is working on your project. Moral rights is not something that can be owned by a corporation. It can only be owned individually. So each creator involved in your project should be signing a moral rights waiver. Similarly, you'll want to make sure your agreements have non-disclosures and confidentiality clauses. And in situations where you are licensing an IP, you'll want to make sure that you've got the sub-licensable rights so that you can turn around and sell your product. This is mostly applicable for tech companies. However, we're talking to a tech group here, so I wanted to make sure that we included that information. Now, you'll also want to be sure that if you're dealing with an open source backend or open source code, you'll want to make sure that the copyleft license includes the ability for you to be able to resell the finished product and not have any other obligations to them. And you'll want to make sure that you've got the ability to do so in different jurisdictions in case you want to expand. So another consideration when you're looking at your IP is filing your IP. Now, we've talked about patents, trademarks, and particularly those two when it comes to where you file. If you're planning, if you're planning on filing your patents and planning on extending to other countries later, you'll want to make sure that you're filing strategically. So what does that mean? Well, you can file in many places. You can file in your home country, but you'll want to make sure that you've got good local council representation to guide you. And the reason for that is that some countries are members of international treaties and others are not. If you're filing in a country that is a member of, say, the Patent Cooperation Treaty, in the case of patents, you'll have the ability to extend your patent to other countries of your choice, depending on who's a member of the PCT or Patent Cooperation Treaty. And you'll be able to have that initial date of filing recognized. Now, if someone else comes up with another invention in another country, the way that these things are looked at is that you make sure that the country that has filed first, or the organization that has filed the first filing, is usually deemed to have protected that invention first, as opposed to another organization that has maybe created the same invention but done so later. And so you'll want to make sure that you're considering those international obligations. And so with the PCT, one of the wonderful things about it is that if you were thinking about moving on with other countries, you can file within those other countries within 30 months. And that's sort of, and if you're not in a PCT country and you make a filing in your home country and then you make filings in other countries, you must do so within 12 months. So that 30-month window sort of grants you a little bit of extra time and allows you the ability to defer some of those costs of paying for your patent application in other jurisdictions. Now, in discussing when, you'll want to think about, and this is in particular to trademarks, you'll want to think about where you're going to file. You really do, in order to be able to protect your trademark, you need to be able to be using it in a real and substantial commercial context. So you'll want to make sure that you're filing it at the time that you're ready to use it. And you'll think about things like whether there's anyone in your home jurisdiction that is using your trademark or something similar to your trademark. And that includes the designs of your trademark as well as the words of your mark. And make sure that you've got that clear space within the market for anybody who may be competition, because otherwise you'll start with your brand and then you'll get knocked out of the market and have to change things up. Also to be considered is if you're planning on moving into other jurisdictions, you'll want to consider things like whether they've got a mark that's similar to yours. And the marks that you're looking for here are marks that are similar to yours within your area of the market. So if you are selling financial applications, you're not really concerned about another company that's similar to you that sells hoses. You really do have to have competition in the market in order for it to be applicable. However, that's also dependent on the relative fame of the mark, the relative amount that it is known and the goodwill that's been generated by it. So a very powerful hose company, of which I could not think of a name, would be able to make a claim against something of the same name, even if it's not in a direct competition, if it's a near competition environment. And I think I've talked a little bit about how the cost can be deferred when you are working through a country that has the international treaties. So watch for things like that. Watch for things like your priority dates, because those are the things that will be considered important if you ever have to enforce your mark or your invention. So key takeaways. You'll want to make sure that you're protecting your IP from the very, very beginning, and you're also considering how you're going to grow as you file your applications for the IP that you are protecting. You want to make sure that that includes all of your contracts, agreements, and employments going forward, even the partnership agreements. If it's just a few people at the very beginning, you'll want to make sure at the outset you understand who owns the IP, and if the partnership ceases to exist, who will own the IP. And you'll also want to make sure that you've got good, strong, knowledgeable local counsel to guide you through the process. And if that means that you're expanding into another country, make sure you've got local counsel in that country so that you understand what the rules are in that country. Different jurisdictions have different protections, different scopes of protections, different lengths of term, and different timelines for payments. So you'll want to make sure that you have a really good knowledge of what's going on the ground, where not only where you're filing from, but in the countries that you are planning on expanding into. And that concludes our presentation. Are there any questions? You can put questions through in the chat if you've got them. Otherwise, thank you very much for your time and hope you enjoy the rest of the conference.